Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Great Lakes Insurance SEV Raiders Retreat Realty Co. In this case, the court considered this issue: is a choice of law clause in a maritime contract unenforceable if enforcement would conflict with the strong public policy of the state whose law is displaced? The case was decided on February 21, 2024. The Supreme Court held that choice of law provisions in maritime contracts are presumptively enforceable under federal maritime law, with narrow exceptions not applicable in this case. Justice Brett Kavanaugh authored the unanimous opinion of the court. The Constitution confers federal jurisdiction over all maritime cases to ensure uniformity across the United States, with federal courts deriving maritime law from various sources such as judicial opinions and scholarly writings. In the absence of established maritime rules, federal courts possess the authority to formulate new, uniform maritime rules. Relevant to this discussion, federal maritime law presumes the validity of choice of law provisions in maritime contracts. The precedent set by the Wilburn Boat case, which permitted state law to address the absence of uniform federal maritime rules, does not extend to choice of law provisions. Therefore, contrary to Raiders' argument, state law does not serve to fill any gaps in this context, reinforcing the federal rules presumption of enforceability for choice of law clauses in maritime contracts. Justice Clarence Thomas authored a concurring opinion to argue that the Wilburn Boat precedent rests on flawed premises and is at odds with the fundamental precept of admiralty law. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kavanaugh delivered the opinion of the court. Maritime contracts often contain choice of law provisions that designate the law of a particular jurisdiction to control future disputes. The enforceability of those choice of law provisions is governed by federal maritime law. Applying federal maritime law in this case, we conclude that choice of law provisions in maritime contracts are presumptively enforceable, with certain narrow exceptions not applicable here. To insure its boat, Raiders Retreat Realty, a Pennsylvania business, purchased a policy from Great Lakes Insurance, a company organized in Germany and headquartered in the United Kingdom. The insurance contract included a choice of law provision that, as relevant here, selected New York law to govern future disputes between the parties. Years later, Raiders' boat ran aground near Fort Lauderdale, Florida. After Raiders submitted an insurance claim, Great Lakes denied coverage. Great Lakes asserted that Raiders breached the insurance contract by failing to maintain the boat's fire suppression system. According to Great Lakes, the breach voided the insurance contract in its entirety, even though the boat's fire suppression system did not contribute to the accident. Great Lakes sued Raiders for declaratory relief in the U.S. District Court for the Eastern District of Pennsylvania. Great Lakes alleged that Raiders breached the insurance contract, and that the breach allowed Great Lakes to deny insurance coverage. In response, Raiders advanced contract claims under Pennsylvania law. Great Lakes countered that Pennsylvania law did not apply to this dispute. Rather, New York law applied under the choice of law provision in the parties' insurance contract. The district court agreed with Great Lakes. The court reasoned that federal maritime law regards choice of law provisions as presumptively valid and enforceable. The court therefore enforced the parties' choice of law provision and rejected Raiders' Pennsylvania law contract claims. The U.S. Court of Appeals for the Third Circuit vacated that judgment. The Court of Appeals held that choice of law provisions in maritime contracts are presumptively enforceable as a matter of federal maritime law, but nonetheless must yield to a strong public policy of the state in which suit is brought. Here, Pennsylvania's public policy regarding insurance. The court remanded for the district court to consider whether applying New York contract law here would violate Pennsylvania's public policy, and whether Pennsylvania law therefore should apply. This court granted certiorari to resolve a split in the courts of appeals regarding the enforceability of choice of law provisions in maritime contracts. Under the Constitution, federal courts possess authority to create and apply maritime law. Article 3 of the Constitution extends the federal judicial power to all cases of admiralty and maritime jurisdiction. That grant of jurisdiction contemplates a system of maritime law coextensive with, and operating uniformly in, the whole country. The purposes of that uniform system include promoting the great interests of navigation and commerce, and maintaining the United States diplomatic relations. To maintain that uniform system, federal courts make decisional law for maritime cases. When a federal court decides a maritime case, it acts as a federal common law court, much as state courts do in state common law cases. Subject to direction from Congress, the federal courts fashion maritime rules based on, among other sources, judicial opinions, legislation, treatises, and scholarly writings. Exercising that authority, federal courts follow previously established maritime rules. No bright line exists for determining when a federal maritime rule is established, but a body of judicial decisions can suffice. In the absence of an established rule, federal courts may create uniform maritime rules. When no established rule exists, and when the federal courts decline to create a new rule, federal courts apply state law. For purposes of this general overview, we will stop there, as the issue of federalism in admiralty and the scope of application of state law in maritime cases is one of the most perplexing issues in the law. The initial question here is whether there is an established federal maritime rule regarding the enforceability of choice of law provisions. The answer is yes. Long-standing precedent establishes a federal maritime rule. Choice of law provisions in maritime contracts are presumptively enforceable. As a leading treatise says, it is well established in admiralty that choice of law clauses will normally be enforced. Courts of appeals have consistently decided that choice of law provisions in maritime contracts are presumptively enforceable as a matter of federal maritime law. Although no recent case of this court has addressed the issue, the court has traditionally enforced choice of law provisions in maritime contracts. The court has recognized, for example, that the parties to a maritime contract may select the governing law by clearly manifesting an intent to follow that law when entering into the contract. The court has stated that it is no injustice to resolve disputes under the law that parties have agreed to be bound by. As the court further opined in 1953, except as forbidden by some public policy, the tendency of the law is to apply in contract matters the law which the parties intended to apply. The court's traditional enforcement of choice of law provisions in maritime contracts corresponds to the court's precedents in the analogous forum selection context. The court has pronounced that forum selection clauses in maritime contracts are prima facie valid under federal maritime law and should be enforced unless doing so would be unreasonable under the circumstances. Like choice of law provisions, forum selection clauses respect ancient concepts of freedom of contract, and like choice of law provisions, forum selection clauses have the salutary effect of dispelling any confusion on the manner for resolving future disputes, thereby slashing the time and expense of pre-trial motions. For those reasons, as courts of appeals have explained, this court's decisions on the enforceability of forum selection clauses dictate the same conclusion for choice of law provisions. That is especially true given that courts historically have expressed more skepticism of forum selection clauses than of choice of law clauses, because forum selection clauses can force parties to litigate in inconvenient places. As courts and commentators have recognized, the presumption of enforceability for choice of law provisions in maritime contracts facilitates maritime commerce by reducing uncertainty and lowering costs for maritime actors. Maritime commerce traverses interstate and international boundaries, so when a maritime accident or dispute occurs, time-consuming and difficult questions can arise about which law governs. Choice of law provisions reduce legal uncertainty. By identifying the governing law in advance, choice of law provisions allow parties to avoid later disputes, as well as ensuing litigation and its attendant costs. Choice of law provisions also discourage forum shopping, further cutting the costs of litigation. Moreover, by supplying some advance assurance about the governing law, choice of law provisions help maritime shippers decide on the front end what precautions to take on their boats and enable marine insurers to better assess risk. Choice of law provisions therefore can lower the price and expand the availability of marine insurance. In those ways, choice of law provisions advance a fundamental purpose of federal maritime law, the protection of maritime commerce. Raiders argues that no established federal maritime rule governs the enforceability of choice of law provisions, and it further contends that federal courts should assess those provisions under state law. Raiders does not specify whether it thinks that federal maritime law should incorporate state law on this issue, or instead that state law is not preempted by federal maritime law and applies of its own force. In any event, Raiders argues that this court's decision in Wilburn Boat Company v. Fireman's Fund Insurance Company precludes a uniform federal presumption of enforceability for choice of law provisions in maritime contracts. But that case did not involve a choice of law provision. Rather, the court simply determined what substantive rule applied when a party breached a warranty in a marine insurance contract. The court concluded that no established federal admiralty rule governed the warranty issue, and the court declined to create a federal maritime rule on that question, both because states historically regulated insurance, and because federal courts were poorly positioned to unify insurance law on a nationwide basis. The court therefore ordered that the warranty issue be tried under appropriate state law. Great Lakes contends that Wilburn Boat's reliance on state law is in tension with the court's modern maritime jurisprudence, which tends to place greater emphasis on the need for uniformity in maritime law. But here, we need not resolve any such tension because Wilburn Boat does not control the analysis of choice of law provisions in maritime contracts. To reiterate, Wilburn Boat did not involve a choice of law provision, and the case therefore affords limited guidance on that distinct issue. Moreover, Wilburn Boat held only that state law applied as a gap filler in the absence of a uniform federal maritime rule on a warranty issue. Here, however, no gap exists, because a uniform federal rule governs the enforceability of choice of law clauses in maritime contracts. In addition, Wilburn Boat rested in part on the difficulty of creating substantive maritime insurance law from scratch through case-by-case adjudication. That concern is absent when the question is whether the parties may choose the governing law to apply. Wilburn Boat also cited states' traditional responsibility for regulating insurance, but preserving that responsibility does not speak to which state law applies in a given case, which is what a choice of law provision addresses. Finally, Wilburn Boat did not prevent this court from concluding, as a matter of federal maritime law, that forum selection clauses are presumptively enforceable. For all of those reasons, Wilburn Boat does not preclude a uniform federal presumption of enforceability for choice of law provisions in maritime contracts. Raiders suggest that even if federal maritime law presumes the enforceability of choice of law provisions in maritime contracts, Wilburn Boat recognized a kind of insurance exceptionalism where this court will apply state law in marine insurance cases. We disagree? Nothing in Wilburn Boat purports to override parties' choice of law clauses in maritime contracts generally, or in the subset of marine insurance contracts specifically. Moreover, in the forum selection context, the Bremen and Carnival crews apply to marine insurance contracts as well as to other maritime contracts. We discern no good reason for a different rule in the choice of law context. Indeed, the uniformity and predictability resulting from choice of law provisions are especially important for marine insurance contracts, given that marine insurance is an integral part of virtually every maritime transaction, and maritime commerce is a vital part of the nation's economy. In applying maritime rules, we also may assess whether our decision produces an equitable result. In considering Raiders' argument for applying state law, it bears recalling Wilburn Boat's aftermath in maritime law and the maritime industry. After Wilburn Boat, maritime actors realized that a lot would depend on which state's law governed each individual maritime dispute, a question that would be unclear in advance. Choice of law provisions soon emerged as a ready answer to that problem, and particularly since the Bremen resolved the analogous forum selection issue in 1972. Most maritime actors have justifiably believed that choice of law provisions are presumptively enforceable as a matter of federal maritime law. That widespread understanding is correct, and Raiders' argument for disrupting that long-standing consensus is essentially a solution in search of a problem. The bottom line, as a matter of federal maritime law, choice of law provisions in maritime contracts are presumptively enforceable. Of course, to say that choice of law clauses are presumptively enforceable as a matter of federal maritime law means that there are exceptions when the clauses are not enforceable. The parties agree that the exceptions are narrow. Indeed, Raiders freely concedes that in most every instance, a choice of law provision contained in a maritime insurance contract will be effective. In particular, the parties agree that courts should disregard choice of law clauses in otherwise valid maritime contracts when the chosen law would contravene a controlling federal statute or conflict with an established federal maritime policy. For example, the Kensington declined to enforce a choice of law clause because the chosen law would have released a carrier from liability for negligence, a result that federal maritime law forbids. The parties further agree that, as a matter of federal maritime law, courts may disregard choice of law clauses when parties can furnish no reasonable basis for the chosen jurisdiction. For example, it would be unreasonable to pick the law of a distant foreign country without some rational basis for doing so. That said, the no reasonable basis exception must be applied with substantial deference to the contracting parties, recognizing that maritime actors may sometimes choose the law of a specific jurisdiction because, for example, that jurisdiction's law is well developed, well known, and well regarded. Raiders does not claim that either of those exceptions applies here. To be specific, Raiders does not assert that any federal statute or established federal maritime policy precludes enforcing the party's choice of law provision, and Raiders does not claim that the party's choice of New York's well-known and highly elaborated commercial law was unreasonable. Unable to successfully invoke those exceptions, Raiders says that federal maritime law should recognize an additional exception when enforcing the law of the state designated by the contract would contravene the fundamental public policy of the state with the greatest interest in the dispute. We disagree with that argument. Indeed, Raiders' request for that novel maritime exception is essentially a repackaged version of its initial argument that the enforceability of choice of law provisions in maritime contracts should be determined by state law. The argument fares no better here, for essentially the same reasons. A federal presumption of enforceability would not be much of a presumption if it could be routinely swept aside based on 50 states' public policy determinations. The ensuing disuniformity and uncertainty caused by such an approach would undermine the fundamental purpose of choice of law clauses in maritime contracts, uniform and stable rules for maritime actors. Raiders' proposed exception also lacks historical roots. This court has never discarded a choice of law provision in a maritime contract, on the ground that enforcement of the choice of law provision would violate state law. On the contrary, the court has enforced those clauses without so much as mentioning state law. nor has the court looked to state law in the analogous forum selection context. Raiders points to a sentence in the Bremen stating that a contractual choice of forum clause should be held unenforceable if enforcement would contravene a strong public policy of the forum in which suit is brought. But that sentence, read in context, was referring to the possibility of a conflict between federal maritime law and a foreign country's law. There, England's state law was not relevant to the case. The Bremen said nothing about the law or public policy of Florida. Carnival Cruise likewise said nothing about the law or public policy of Washington. Raiders' position similarly finds no footing in the decisions of the courts of appeals. The opinion of the Third Circuit in this case is the first by a federal court of appeals to hold that a state's strong public policy may justify disregarding a maritime choice of law clause. The lack of case law supporting Raiders' state law argument comes as no surprise, given that Raiders' position would merely allow the substitution of one body of state law, the law of the state with the purported greatest interest in the matter, for another, the law of the state designated by a choice of law provision. As Raiders seems to acknowledge, federal maritime law offers no reason to categorically prefer the law of one state over another state. Here, for example, no federal maritime interest supports applying Pennsylvania law rather than New York law. For the same reasons, we disagree with Raiders' related suggestion that we adopt the choice of law approach set forth in Section 187(2)b of the Second Restatement of Conflict of Laws. In relevant part, that subsection says that choice of law provisions are enforceable unless they conflict with a fundamental policy of a state which has a materially greater interest than the chosen state in the determination of the particular issue. As the commentary to the restatement carefully explains, however, that rule arose out of interstate cases and does not deal directly with federal-state conflicts, including those that arise in federal enclaves like maritime law. For reasons already stated, that restatement rule is a poor fit for maritime cases. It would operate like a general exception for state law that would prevent maritime actors from prospectively identifying the law to govern future disputes. The Section 187(2)b exception would require parties to litigate which state possesses the materially greater interest in the dispute, and thereby create significant uncertainty. As explained above, no federal maritime interest favors injecting that kind of disuniformity and unpredictability into maritime commerce. We therefore decline to adopt Section 187(2)b for federal maritime law. In sum, choice of law provisions in maritime contracts are presumptively enforceable as a matter of federal maritime law, with certain narrow exceptions, and no exception to the presumption applies in this case. We reverse the judgment of the Court of Appeals. It is so ordered. Justice Thomas concurring. I join the Court's opinion in full because it correctly concludes that federal maritime law governs the enforceability of choice of law provisions in maritime contracts. In arguing that state law should govern, Raiders Retreat Realty relies principally on this Court's decision in Wilburn Boat Company v. Fireman's Fund Inns Company. I write separately to highlight how Wilburn Boat rests on flawed premises and, more broadly, how the decision is at odds with the fundamental precept of admiralty law. This Court has already retreated from Wilburn Boat's unsound holding, limiting it to local disputes. Litigants and courts applying Wilburn Boat in the future should not ignore these developments. The Constitution extends the judicial power to all cases of admiralty and maritime jurisdiction. We have long understood this grant of jurisdiction to establish a uniform body of substantive law called the general maritime law. For almost 150 years before Wilburn Boat, it was well established that marine insurance disputes fell within that admiralty jurisdiction, and it was widely accepted that courts applied general maritime law in such disputes as a result. Wilburn Boat upset this understanding by inviting courts to apply state law in a broad range of marine insurance disputes. That break from settled practice was unwarranted. Wilburn Boat involved an insurance claim on a small houseboat that was destroyed by fire while moored in Lake Texoma, an artificial inland lake. The houseboat's owner conceded that he breached the marine insurance policy's express warranty limiting his use to private pleasure by carrying passengers for hire. Even though that breach was unrelated to the fire, the insurer declined coverage on breach of warranty grounds, arguing that federal maritime law requires literal compliance with express warranties, and that any breach thus releases the insurer from liability. The owner countered that Texas law, not federal maritime law, should determine the consequences of a breach of warranty, and that breaching the private pleasure warranty would not justify denying coverage under Texas law. To resolve this choice of law dispute, the court posed two questions. 1. Is there a judicially established federal admiralty rule governing these warranties? 2. If not, should we fashion one? Answering both questions in the negative, this court concluded that state law governs the effect of a breach of warranty in a marine insurance policy. Wilburn Boat's rationale is deeply flawed. The court's first conclusion, that there was no established federal admiralty rule requiring literal compliance with express warranties, is indefensible. Treatises from the early 19th century to the 20th century recognized the literal compliance rule as part of the general maritime law governing marine insurance. By the time of Wilburn Boat, at least 5 courts of appeals had applied that rule in marine insurance cases, and, as Justice Reed highlighted in dissent, no case held to the contrary. The court's only rejoinder was that some court of appeals decisions may have drawn the literal compliance rule from state or general common law, rather than general maritime law. Even so, the court never explained why the 2 decisions that identified general maritime law as the source of the literal compliance rule were not enough to establish a federal admiralty rule, nor did it grapple with the seemingly universal endorsement of the rule in marine insurance treatises. At any rate, that some decisions were not explicit about the source of the literal compliance rule is unsurprising, given the common understanding that general maritime law applied in admiralty cases, and it is telling that many of those decisions rely on the classic marine insurance treatise, Arnold on Marine Insurance. In short, at the time of Wilburn Boat, the existence of an established federal maritime rule addressing the effect of a breach of warranty could not plausibly be questioned. Justice Thomas concurring. I join the court's opinion in full because it correctly concludes that federal maritime law governs the enforceability of choice of law provisions in maritime contracts. In arguing that state law should govern, Raiders Retreat Realty relies principally on this court's decision in Wilburn Boat Company v. Fireman's Fund Inns. Company I write separately to highlight how Wilburn Boat rests on flawed premises and, more broadly, how the decision is at odds with the fundamental precept of admiralty law. This court has already retreated from Wilburn Boat's unsound holding, limiting it to local disputes. Litigants and courts applying Wilburn Boat in the future should not ignore these developments. The Constitution extends the judicial power to all cases of admiralty and maritime jurisdiction. We have long understood this grant of jurisdiction to establish a uniform body of substantive law called the general maritime law. For almost 150 years before Wilburn Boat, it was well established that marine insurance disputes fell within that admiralty jurisdiction, and it was widely accepted that courts applied general maritime law in such disputes as a result. Wilburn Boat upset this understanding by inviting courts to apply state law in a broad range of marine insurance disputes. That break from settled practice was unwarranted. Wilburn Boat involved an insurance claim on a small houseboat that was destroyed by fire while moored in Lake Texoma, an artificial inland lake. The houseboat's owner conceded that he breached the marine insurance policy's express warranty limiting his use to private pleasure by carrying passengers for hire. Even though that breach was unrelated to the fire, the insurer declined coverage on breach of warranty grounds, arguing that federal maritime law requires literal compliance with express warranties, and that any breach thus releases the insurer from liability. The owner countered that Texas law, not federal maritime law, should determine the consequences of a breach of warranty, and that breaching the private pleasure warranty would not justify denying coverage under Texas law. To resolve this choice of law dispute, the court posed 2 questions. 1. Is there a judicially established federal admiralty rule governing these warranties? 2. If not, should we fashion one? Answering both questions in the negative, this court concluded that state law governs the effect of a breach of warranty in a marine insurance policy. Wilburn Boat's rationale is deeply flawed. The court's first conclusion, that there was no established federal admiralty rule requiring literal compliance with express warranties, is indefensible. Treatises from the early 19th century to the 20th century recognized the literal compliance rule as part of the general maritime law governing marine insurance. By the time of Wilburn Boat, at least 5 courts of appeals had applied that rule in marine insurance cases, and, as Justice Reed highlighted in dissent, no case held to the contrary. The court's only rejoinder was that some court of appeals decisions may have drawn the literal compliance rule from state or general common law, rather than general maritime law. Even so, the court never explained why the 2 decisions that identified general maritime law as the source of the literal compliance rule were not enough to establish a federal admiralty rule, nor did it grapple with the seemingly universal endorsement of the rule in marine insurance treatises. At any rate, that some decisions were not explicit about the source of the literal compliance rule is unsurprising, given the common understanding that general maritime law applied in admiralty cases, and it is telling that many of those decisions rely on the classic marine insurance treatise, Arnold on Marine Insurance. In short, at the time of Wilburn Boat, the existence of an established federal maritime rule addressing the effect of a breach of warranty could not plausibly be questioned. The Wilburn Boat Court's justification for not creating a federal admiralty rule is equally problematic. It reasoned that general insurance regulation is an area that historically has been left to the states, and that courts are ill-suited for crafting marine insurance law on a case-by-case basis. The fact that states have traditionally provided rules of decision for general insurance law is no reason to leave marine insurance law to them. States have traditionally provided rules of decision for general contract and tort law, yet federal courts continue to develop maritime law in those areas. Wilburn Boat Court's doubts about the ability of judges to craft marine insurance rules on a case-by-case basis is simply a critique of the common law process. But federal courts exercising admiralty jurisdiction act as common law courts, and the difficulties inherent in that role do not justify abandoning it. A noticeable deficiency of Wilburn Boat was its failure to even acknowledge the uniformity principle, a singularly important concept in admiralty law. We have long recognized that the Constitution's grant of admiralty jurisdiction referred to a system of law coextensive with, and operating uniformly in, the whole country, and empowered federal courts to maintain that national system using a common law process. Only a uniform system of maritime law, the court has explained, can ensure the consistency at which the Constitution aimed on all subjects of a commercial character affecting interstate and foreign commerce. This need for uniformity has been the touchstone for determining the scope of admiralty jurisdiction and the extent to which state law can be given effect in admiralty cases. Notwithstanding this settled principle, however, Wilburn Boat said nothing about uniformity. It did not so much as consider whether a need for uniformity required a federal rule on the effect of breaching an express warranty in a marine insurance contract. This silence is inexplicable given that both Justice Frankfurter's concurrence and Justice Reed's dissent discussed uniformity at length. As Justice Reed lamented, the court's decision strikes deep into the principle of a uniform admiralty law, and worse, it did so without explaining why. Unsurprisingly, Wilburn Boat has been met with universal criticism over the past 70 years. A mere 2 years after the decision, the nation's foremost admiralty scholars wrote a stinging critique in their treatise. Wilburn Boat's rationale, they explained, suggests that state law provides the rule of decision when it happens that such cases have not presented themselves to the federal courts in such number, or with the issues so posed as to result in decision of the point involved. This, they concluded, is a nightmarish solution, because some of the most important and obvious propositions in marine insurance law are rarely litigated. One exhaustive study of the opinion also concluded that Wilburn Boat was poorly reasoned, and its holding poorly articulated. It explained that Wilburn Boat did not articulate any convincing theory of the extent to which uniformity is a basic characteristic of maritime law, showed little appreciation for the judiciary's role in fashioning the general maritime law, and failed to produce a decision or analysis that would provide guidance to the lower courts. And a modern treatise explains that Wilburn Boat has 1. Produced a crazy quilt pattern of federal-state regulation of marine insurance, and 2. Bogged the courts down in complex and confusing choice of law questions. It is little wonder that this court has retreated from Wilburn Boat in subsequent decisions, implicitly cabining its reach to localized disputes in accordance with Justice Frankfurter's concurrence. In Kosick, for example, this court held that general maritime law, not a state statute of frauds, governed the validity of a shipowner's oral contract with a seaman. The court attributed the decision in Wilburn Boat in part to the inherently local nature of its dispute about a contract of insurance on a houseboat established in the waters of a small artificial lake. 50 years later, we endorse this narrow reading of Wilburn Boat in Kirby, holding that general maritime law governed a maritime contract for the carriage of goods primarily by sea. We explain that when a contract is a maritime one, and the dispute is not inherently local, federal law controls the contract interpretation. Today's decision further erodes Wilburn Boat's foundation, and rightly so. In light of these decisions, it is not clear what, if anything, is left of Wilburn Boat's rationale. Yet Raiders and some courts continue to understand Wilburn Boat to require application of state law in circumstances far different from the inherently local dispute at issue there. But see Lloyds of London v. Pagan-Sanchez, recognizing that Wilburn Boat applies only to inherently local disputes. Litigants and courts should heed our instruction that general maritime law applies in maritime contract disputes, unless they so implicate local interests as to beckon interpretation by state law. Wilburn Boat reaches no further. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.